And just like the riots of the summer of 2020 and the looting that continues today, the White House turns a deaf ear to violence, and they swallow their tongue when the violence supports their own agenda. Listen, these threatening so-called protests at the justices' homes are a violation of the law of this land. They're not valid protests. These are attempts to intimidate and influence the court to destroy the independence of this judiciary. This violence is wrong. It's evil. It's an attack on Christianity. It's an attack on the faith and values of this nation we're founded upon. Americans know it. We all feel the hatred. And I have to note, Americans understand the majority leader has provided no such condemnation, but rather has decided to once again bring back his Abortion on Demand Act to the Senate floor. This bill is the most egregious, the most horrific attack on the lives of unborn children and the health of moms in American history. If Democrats had their way, these babies, these twin babies I delivered more than a decade ago, could have been aborted the moment prior to the C-section. The overturning of Roe versus Wade simply returns this emotional issue back to the states, to the elected voices of the people. No more, no less. And the Mississippi Dobbs case simply protects life after 15 weeks, when a baby can feel pain, when a baby can recognize its mom's voice, when a baby can recognize the voice of its sibling. But let me tell you exactly what the Democrats' extreme Abortion on Demand Act would do. It goes far and beyond Roe versus Wade. This bill invalidates any and all state laws that protect not just the unborn child, but the health and well-being of the mom as well. It likely leads to American taxpayer dollars funding abortions at home and around the world. It's truly an attack on our faith. This bill will tie up faith-based hospitals and courts for not offering abortion services. This bill allows sex-based abortions. It eliminates the requirement for informed consent of the patient or parental consent. This bill eliminates conscious protections. As an obstetrician myself, this hits near and dear to my heart. This bill is an attack on my faith and the attack of the faith of many doctors and nurses who refuse to take part in abortions. They would be forced out of their professions. They would be forced out of medical schools, out of residency programs. So many aspiring students would decide not to go into medicine. This bill is a total disregard to the mother's health. By placing no value on the mom's life and well-being, this radical bill eliminates the health standards of a surgery center for this procedure to be performed in a surgery center. In fact, this bill would allow these services to be offered in a garage or a backroom apartment. And shockingly, it provides the right to provide abortions to any health care provider, not necessarily a physician, but to certified nurse midwives, nurse practitioners, a physician assistant. This bill will lead to the death and infertility of many, many women. This procedure is not a simple procedure. Should not be placed in the hands of inexperienced people. This is a procedure, this type of procedure is only done after 4 years of undergraduate, 4 years of medical school, and probably 2 or 3 years of residency. In the most skilled of hands, this type of procedure can lead to serious loss of life. And finally, and more specifically, this bill strikes down state laws that restrict telehealth abortions. These are chemical abortions, and they would become a common means of birth control, again, leading to many, many more visits to the emergency rooms for these women who are taking medicines unsupervised. And finally, I have to correct something one of my friends across the aisle said. He stated that we from the pro-life community would not treat women with ectopic pregnancies. Nothing is further from the truth. This case of Roe versus Wade has nothing to do with treating ectopic pregnancies. I personally have treated hundreds of women with ectopic pregnancies. I believe that life begins at conception, but treating an ectopic pregnancy is a life-threatening situation for the mom. And the Catholic Church supports the treatment of ectopic pregnancies. But that's the type of scare tactics my colleagues across the aisle want to use. Finally, Mr. President, just let me conclude with this. I never imagined I'd be fighting harder to save the lives of moms and babies on the floor of this Senate than I did in the emergency room or the delivery room in my obstetrics practice for some 30 years. Thank you, and I yield back.
Mr. President.
Senator from Utah.
Mr. President, my colleagues and I are here today to highlight the fact that our Democratic colleagues have shown the American people how truly radical they are when it comes to abortion. The Women's Health Protection Act, what I believe should be better known as the Abortion on Demand Until the Moment of Birth Act, casts a vision of abortion in America, one utterly without limitation. Federalism is one of the truly genius ideas behind the U.S. Constitution. Federalism means that we make the majority of our decisions at a more local level rather than at the national level. When we rely on the principle of federalism, more people across the country have more reason to be content with the laws they have. People have a greater say in the legislative process at the local level, which means they get more of the kind of government they want and less of the kind of government they don't want. For nearly the last half century, the decisions in Roe versus Wade and Planned Parenthood versus Casey have abused the Constitution by reading into the Constitution a right that exists nowhere in the Constitution. These wrongly decided cases have wreaked havoc on public trust in government, on the Republican nature of our government, on the public's understanding of the Constitution. More gravely, these decisions have permitted the euphemistically described, quote-unquote, termination of 63 million American lives. That's more than 45 times the number of American lives lost in war since the founding of our nation, every war combined. 45 times that. Let that sink in for a minute. Abortion is a tragedy. It's one that's scarring our nation's history because of what it says about how we respect human life. Those scores of millions of lives represent, each and every one of them, unique and unrepeatable genetic makeups and identities and potentials. They represent the loss of Americans of all races, varying physical and mental abilities, all political affiliations, and professions, with many targeted because of their race, sex, or disability. Their termination is a loss of ideas, of innovation, and of compassion. Those abortions erase all potential families and communities. Those abortions represent the loss of infinite potential connection and love. Abortion is a tragedy that scars our history. So when I read Justice Alito's draft opinion in Dobbs versus Jackson Women's Health Organization, I was elated. Elated because it relies on federalism and a sound reading of the Constitution to reassert that there is no constitutional right to an abortion just because a combination of lawyers wearing robes 48 years ago decided that would be the case does not make it so. Our Constitution is difficult to amend, and it's deliberately that way. They didn't follow this procedure. They tried to circumvent it, and they were wrong. Regulating abortion is a matter reserved for the American people and their elected representatives, not 9 unelected judges. For that very reason, a number of people have turned against it, and because they can't characterize it the way that it actually is, they mischaracterize it. Then they go so far as to encourage people to show up to the homes, the private residences of the Supreme Court justices in question. There is no reason to do this that doesn't involve an implicit threat of violence. When you show up at someone's home, you're sending an unmistakable message. We know where you sleep. That's why this is expressly prohibited under federal law. There's a federal criminal law prohibiting this under 18 U.S.C. Section 1507. Now, stunningly, the White House, the president's personal spokesperson, Jen Psaki, just in the last few hours, has repeated this charge, has encouraged people to do this, saying, quote, we certainly continue to encourage protests outside of judges' homes. This is wrong, and I call on the President of the United States personally to undo this. He is encouraging unlawful behavior that is inherently dangerous and is inherently threatening. This radical bill, it's emerged in the days immediately following the leak of the Dobbs draft opinion, is shrouded in the lie of protecting women's health while allowing for killing babies by any means, however gruesome, violent, atrocious, heinous, or cruel, right up until the moment of birth, preempting any state laws that might choose to protect life. Those late-term abortions not only kill viable babies, but they're unreasonably, needlessly cruel, and they are extremely dangerous procedures for the mothers themselves. Unlimited abortion is also widely unpopular. Only 17% of Americans believe that that's the right policy. Among medical professionals, the feelings are similar. Research shows that over one-third of OBGYNs in America would not even refer a patient for an abortion. This bill is, as written, would require those same doctors not only to refer but also to provide abortions or risk their employment. Notwithstanding any ethical objection they may have to it, notwithstanding any religious objection they may have to it, by waiving the Religious Freedom Restoration Act, carving it out, the Religious Freedom Restoration Act, or RFRA as it's known, so a religious liberty protection enacted by an overwhelming supermajority of Democrats and Republicans. This bill would require hospitals and healthcare workers to perform abortions in violation of their own religious convictions. With this bill, Democrats in the House and the Senate are attempting to take this issue away from the people, away from the states, and force their radical abortion agenda on the American people as a whole. Now, make no mistake, this is their vision for America, fully funded by the abortion industry. It also perpetuates the tragedy of abortion, one that's a scar on our country's history. I hope and pray that state legislatures across the country will follow the example of the state of Utah and pass laws to protect the lives of preborn babies and their mothers. Thank you, Mr. President.
Mr. President. Senator from Indiana. Every year in schools around our country, students are taught about the Declaration of Independence. This remarkable document outlines the ideals on which the United States was founded and the principles on which our government and our very identity as Americans are based. Perhaps best known and most quoted from the Declaration is that line about all being endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. From our earliest days, when such a concept truly was revolutionary, to the present day, as Americans, we believe in the dignity and value of every human person. This is an ideal that we should always aspire to, and in the spirit of that conviction, I believe that our nation has a moral responsibility to protect unborn children, to protect life. Through amazing advances in science, families and medical professionals now know that at 15 weeks, a baby can feel pain, a baby can move fully formed fingers and toes, a baby has a fully developed heart pumping 26 quarts of blood per day. Despite what these advances in modern science tell us, the current abortion policy in the United States is more in line with communist China and North Korea. We are only one of 7 countries around the world that allow abortion to take place past the point at which a baby can feel pain in the womb. One of 7 countries in the world. Some Americans might be surprised to learn that even in progressive Europe, 47 out of 50 countries have limits on abortion after 15 weeks. Yet the legislation before the United States Senate would block states from protecting the unborn and enshrine late-term abortion into our federal law. Going beyond codifying Roe versus Wade, this sweeping legislation would strike down common sense, broadly supported laws that many states have adopted since that decision, including laws meant to protect the health and safety of mothers. This bill does nothing to protect the health and safety of women, and it would certainly not protect the unborn. And it would make these sweeping changes contrary to the wishes of the majority of Americans. In fact, recent polling found that 61% of Americans say abortion should either be illegal or that the policy decisions associated with abortion should be left up to the states. So I would urge my colleagues to vote against this bill, given our increased knowledge and understanding of how babies develop, given our understanding of the science. This is simply the wrong direction to take public policy. I also want to take a moment and acknowledge that the issue of abortion is a very tough one for so many Americans. And given recent developments, this is a topic on the minds of many Hoosiers and many Americans. I understand that. And I want to reiterate my commitment to helping mothers and families choose life and supporting them in that choice. We must ensure mothers and unborn children are cared for, loved, and supported. And this includes increasing the resources available to help women facing unexpected pregnancies. We must support America's 2,700 pregnancy centers that provide vital services to millions of people each year at virtually no cost, as well as provide more support for adoptive services. These steps are vital as we seek to further promote a culture that values and protects life. Now let's remember and live up to that founding American ideal. We believe in the dignity and value of every human person. Thank you, Mr. President.
From Mississippi.
The senator from Indiana and join him and my other colleagues in decrying the legislation that we will be asked to move to the floor tomorrow. But before I speak on the substance of the bill, it needs to be reiterated why this bill is even before us. The only reason we're debating this bill today is because an extreme and unprecedented breach of protocol took place in the Supreme Court. The leaked draft in the Dobbs case was a full-blown assault on the United States Supreme Court and on the independence of our judiciary. It was an attempt to incite mob pressure against the justices, which has in part succeeded by inciting pressure against the justices, and an attempt to bully them into changing their final votes. And I do trust, based on the information we have about the 9 justices, is that that attempt will not be successful. We saw over the weekend disturbing videos of protesters outside their homes, outside the homes of Supreme Court justices. There's growing concern for the safety of our Supreme Court justices and the safety of their families. This is shameful, Mr. President. A Supreme Court justice should never have to fear for his or her safety or the safety of their families for doing their jobs. We, as elected members of the Congress, are subject to public opinion. The Supreme Court is not supposed to be subject to public opinion and should never have to fear for their safety. The leak and the mob reaction should be condemned by both parties in the strongest possible terms. And yet, there have been very few voices on the other side of the aisle addressing this matter. Certainly, the majority leader of the Senate has not said a word about the outrage of the leak or the mob protests, nor has the President of the United States. What happened to respect and care for our institutions? Instead of protecting the court, our Democratic friends seem to be, whether inadvertently or not, legitimizing this attack on the court by moving to consider extreme legislation which is out of touch with the mainstream of Americans. And so now let me speak briefly about the legislation. It has been said that this is a mere codification of the court's holding in Roe versus Wade. That is, in fact, not the case. Instead, the bill that we will be asked to move to the floor tomorrow is an attempt to expand abortion dramatically across this country, to expand abortion in a way that only a small handful of the most repressive governments on the face of the earth permit. The bill would eliminate even the most modest protections for unborn children across all 50 states. It would force all 50 states to allow gruesome late-term abortions that even the political left all over Europe have long ago outlawed. As my friend from Indiana said earlier, some 47 European countries generally ban abortion after the first 15 weeks. Banning abortion after 14 weeks are our allies of France and Spain. Banning abortion after 13 weeks, Finland. Banning abortion after 12 weeks, Germany, Belgium, Italy, Switzerland. Certainly not governments that are thought of as prisoners of the extreme right. The nation of Portugal generally bans abortion after 10 weeks. Of course, as we know, the Mississippi law that brought this case to the Supreme Court, the Dobbs case, has a slightly more permissive provision than even these friends that I just mentioned from Western Europe. It would be a 15-week ban. But what this bill that we're asked to vote on tomorrow, and which certainly will fail, would push America further outside of the global mainstream than we already are, and we already are way outside this mainstream. Because of scientific advances, we know that an unborn child's heartbeat begins at 6 weeks. We know a child can feel pain as early as 20 weeks. Many of us, including my wife and I, have put the sonograms of our grandchildren, have displayed them on our refrigerators in our homes. What we know about the development of children, their faces, their eyelashes, has brought about a change in the minds of many Americans. In 1996, 56% of Americans called themselves pro-choice. Only 33% said they were pro-life. But because of science, and because of those sonograms, and because of what we know about their ability to feel pain, their movements, their eyes blinking, their eyelashes, today the two sides are just about evenly split, pro-choice and pro-life. But even those who identify themselves as pro-choice are deeply opposed to late-term abortions. And make no mistake about it, if somehow the Schumer bill tomorrow were to pass, late-term abortions would be legal in all 50 states. 81% of Americans think late-term abortions should be illegal. Our friends on the Democratic side should think about that. This bill goes against 81% of American public opinion in that regard. 65% say abortions should be illegal in the second trimester, not the third trimester, in the second trimester, 65% of Americans. I hope our Democratic friends across the aisle think about that before they vote for this extreme piece of legislation brought by the Democratic leader, which would put us in league with the People's Republic of China, with all of their respect for life, with North Korea, with its deplorable record of respecting human life. With those two countries and 5 others on the extreme left, it would put us in league with them. That's not where the American people want us to be, Mr. President. If a state has a 24-hour waiting period, for example, the Schumer bill tomorrow would outlaw that. Taxpayer funding of abortion, the Hyde Amendment, which prohibits this and has done so for decades and decades, would be abolished. The parental rights of teenage girls to have a say and to be able to counsel their daughters on the pivotal decision about having an abortion would be eliminated by this, and religious exemptions. A practicing Catholic who deep in their soul understand this to be infanticide would be required, if they're a physician, to perform an abortion with no religious exemption. Is that what my colleagues on the other side of the aisle are hoping for? It's what they would get if the Schumer bill were to pass. Mr. President, this is not a serious attempt at consensus building. This bill simply reflects, regrettably, the iron grip that Planned Parenthood has on one of our major political parties in this country. We will reject this effort tomorrow. I commend my colleagues who intend to stand with the American people and vote no on this attempt to rank us with the worst regimes on the face of the globe and impose late-term abortions on the entire country. I yield the floor, Mr. President.
Senator from Wisconsin.
Mr. President, I am on the floor here today to address the same topic as my colleague who just spoke. And before I jump into prepared remarks, I wanted to offer just a few points of rebuttal because on this topic, it seems so frequently that we all talk past each other and don't genuinely listen to one another. The Women's Health Protection Act of 2022, which I lead with Senator Blumenthal, would indeed codify Roe versus Wade, but it would additionally give clarity to the states about what further restrictions they could put in place. I hail from the state of Wisconsin, where our state legislature over many, many years has brought forth all sorts of measures, some of which have been signed into law, many of which have been challenged in court, some of which have been vetoed. But these are restrictions on access to comprehensive reproductive health care, including abortion care, that limit access, that make it much more difficult, which is what Roe versus Wade intended to prevent. And they have nothing to do with the health or the life of the mother. In fact, in some cases, they actually do harm to maternal life and health. There are measures in places across the United States that deal with the corridor width of clinics. The corridor width. It would force, if these laws went into effect, many clinics to have to either reconstruct themselves or move. This is clearly something meant to limit access. There are laws and bills that relate to admitting privileges at local hospitals, which are absolutely not medically necessary, and will allow all the area hospitals to team up to deny those privileges, and then the clinic won't have a physician able to work there. There are 24-hour waiting periods. I listened to what my colleague had to say about a blanket overturning of Roe versus Wade, and it would mean that when a woman's life was in jeopardy at some point into her pregnancy, she wouldn't have the ability to save her life and her reproductive health because she wouldn't have access to abortion care. And to characterize this bill as extreme, in my mind, is so opposite the truth. Because to me, what is extreme is forcing, say, a teen to bring a rapist's child to term, or forcing a young woman to give birth to her sibling in cases of incest. My colleague talked about the polls. I don't know what he was looking at. He was talking about pro-choice versus anti-choice. Everything I've seen showed that the overwhelming majority of Americans believe that Roe versus Wade is settled law and should remain in place. And only a small percentage believe it should be overturned in its entirety. So on to my prepared remarks. Mr. President, I rise today to join my colleague, Senator Richard Blumenthal, in support of the Women's Health Protection Act of 2022, a bill that would protect a woman's right to access safe abortion care throughout the United States, no matter where she lives, without unnecessary and unwanted political interference. Congress is responsible for enforcing every American's fundamental rights guaranteed by our Constitution. Throughout history, when states have passed laws that make it harder or even impossible to exercise those rights, Congress has taken action to put in place federal protections. I want to remind my colleagues of this responsibility, and I also want to share a story from one of my constituents. Angela and her wife, Abby, knew they wanted to start a family, so they sought treatment at a fertility clinic in Wisconsin. In 2019, after years of trying, Angela became pregnant. It was a pregnancy they had wanted more than anything. But Angela soon found out that she had what is called a molar pregnancy. This occurs when a tumor forms instead of a healthy placenta. Her pregnancy was not viable. Her doctors moved quickly, and Angela had a safe and legal abortion. She wrote to me earlier this week, and I quote, "Had abortion been illegal, I would have died." Access to a safe abortion saved Angela's life. For others, an abortion kept a family out of poverty or allowed them to complete their education or start a career. Abortions have protected women from being tied to their rapists and spared them of the emotional and physical trauma of carrying an unviable pregnancy to term. I was only 10 years old when Roe versus Wade was decided. For 50 years, just about, this decision has stood. In the words of Justice Kavanaugh, it is, quote, settled as a precedent of the Supreme Court. But apparently precedent means nothing. Access to safe and legal abortion is under direct attack as an activist Supreme Court appears poised to legislate from the bench and take a constitutionally protected right away from tens of millions of Americans. For women like Angela, the gravity of this draft decision from the Supreme Court cannot be overstated. Americans can remember when back alley abortions killed and sterilized women across the country. This decision, if finalized, will not stop abortions from happening. It will only prevent safe abortions from happening, and it will disproportionately impact poor women and women of color who will not have the privilege of making their own health care decisions. If Roe is overturned, 13 states would immediately ban abortions, and others, of course, would move to do so. If Roe is overturned and we don't pass the Women's Health Protection Act, Wisconsin women will be taken back into the mid-1800s. What do I mean by that? We have a law on our books in Wisconsin which criminalizes the abortion procedure. If Roe is overturned, doctors in Wisconsin would be charged with felonies for performing abortions and face up to 6 years in prison and $10,000 in fines. The rights of victims of rape and incest would be taken away. The right for women to choose for themselves and their families would be taken away. I sure am not taking women in Wisconsin back to 1849, and we cannot allow an activist Supreme Court to leave this generation of women behind with fewer rights than their mothers and their grandmothers enjoyed. The Women's Health Protection Act is the only bill that can put an end to the restrictive state laws that have already put thousands of women in jeopardy. The legislation meets the urgent need to protect the provider-patient relationship, protect the healthcare professionals who provide care, and protect the freedom and constitutional rights of women to access this care. I believe a woman's right to choose is protected under the Constitution, and so do the clear majority of Americans who want Roe versus Wade to be upheld. It is our responsibility to take action for women like Angela and on behalf of the American people, and I urge my colleagues to vote yes on the motion to proceed to the Women's Health Protection Act of 2022. And with that, I yield.
Mr. President,
Senator from Minnesota.
I ask unanimous consent that Melody Tan and Sarah Alexander, my fellows in my office, be granted floor privileges for the remainder of the 117th Congress.
Without objection, so ordered.
Thank you. And thank you, Senator Baldwin, for your thoughtful remarks. Mr. President, I rise today in support of the Women's Health Protection Act, and I urge my colleagues to join us in standing up for fundamental rights to freedom, autonomy, and self-determination. Make no mistake, that is what this vote is about. Who has the power, who has the freedom to decide when your own health, livelihood, and life are on the line? There is nothing more American than the value of freedom and individual autonomy. And yet, the United States Supreme Court is about to declare that women in this country are not guaranteed the freedom to make their own private decisions about abortion. Justice Alito, Mitch McConnell, and Senate Republicans and radical Republicans in state legislatures around the country believe that they should have the power, that they know better than American women, whose lives and stories they will never know. To that I say, how dare they? When I worked at Planned Parenthood, I saw firsthand the capacity of women to make good decisions about their health, their body, and their lives. To suggest otherwise is insulting to the dignity of women as full adult human beings and as equal citizens in this nation. But that's where we are. Justice Alito's draft opinion is a wake-up call and a call to action. Reading his opinion was like a gut punch, but it is not a surprise, and it didn't just happen. This is the result of a decades-long campaign by Republicans and their dark money donors to put anti-choice justices on the Supreme Court, to overturn Roe, and to strip women of their constitutional rights. And this is why this vote is so important, Mr. President. For the first time in my living memory, the Supreme Court is about to take away a fundamental constitutional right. And it is important that Americans see who is on their side and who is responsible for this. Extremist Republicans have been working for this goal for decades. And yet, now that this moment is almost here, they keep trying to change the subject. In fact, they want to talk about anything but, including when they spread misleading information about what the Women's Health Protection Act would really do, which is to put the protections of Roe into statute. So why are Republicans running from this issue after having campaigned on it for years? Well, because Americans don't want to overturn Roe, and anti-choice Republicans, they know this. They know that they are on the wrong side of history, on the wrong side of public opinion, and over half the American electorate. And that is why this vote is so important. We will not let them dodge their responsibility for this outrageous attack on women's freedom. Now, some Republicans are saying that this is all a bit of a tempest in a teapot, and they say, don't worry, all the Supreme Court is about to do is to hand power back for the states to decide on abortion. So, colleagues, do not believe this. The American people deserve to know where this goes next. Today, we are fighting on the Senate floor to preserve in law the basic protections of Roe v. Wade. But extremist Republicans, they've been clear. Their end goal is to secure a nationwide ban on abortion. As Senator McConnell said this weekend, it's not a secret that where the Senate Republican caucus are, where that they are opposed to reproductive rights. And if Senate Republicans win the majority, a nationwide ban is, quote, worthy of debate. That is the post-Roe future if Republicans are in charge. Now, even though a majority of Americans in all states believe that abortion should be legal, Republicans have been clear that a nationwide ban, that's their goal. And at the same time, Republican state legislatures are brazenly moving forward. They're moving forward extremist policies that go way beyond depriving women of their essential freedoms. They punish and criminalize women. Take, for example, a Missouri mother of two facing a high-risk pregnancy who travels to Illinois for an abortion because she is worried about being there for her existing children. Missouri Republicans want her to be labeled as a felon when she returns home. Or take a woman in Louisiana who has an abortion after her IUD failed and she had an unexpected pregnancy. Louisiana Republicans want her convicted of homicide. Or take the Texas woman who hoped and prayed for years for a baby, only to have her doctor find a fatal fetal anomaly at 22 weeks. Texas Republicans want her to carry that pregnancy for another 18 weeks, no matter the risk to her life and no matter the trauma she faces, as people congratulate her on her upcoming baby when she knows she will never know that child. And so I say again, how dare these Republicans think that they know better than the women who live these stories? This is the post-Roe world that Republicans want, and we won't stand for it. And if you think this struggle doesn't affect you or someone you care about, think again. 1 in 4 American women will have an abortion. Women who are Democrats, Republicans, independents, women from all places and all religious faiths. For these women, abortion isn't about politics. It's about health care. Most of them never expected to be part of this statistic, but life doesn't always go as we plan. And every day, women deal with situations they never imagined, and they deserve the freedom and the autonomy to decide for themselves what to do and what is best for them. With this vote to pass the Women's Health Protection Act, we are showing who we stand with and what we believe, the fundamental freedom of people to make the best decisions for their health, their families, and their futures. Thank you, Mr. President. I yield the floor.
Mr. President.
Senator from Washington.
Mr. President, I ask unanimous consent for the following senator to be permitted to speak prior to the scheduled vote. Myself for 20 minutes, Senator Toomey for 5 minutes, and Senator Brown for 5 minutes.
Without objection.
Thank you, Mr. President. I'm not sure I'll use all 20 minutes, but you never know. On a subject this important and this vital to women and families across America, it may take a little more than a few minutes to talk about this issue. And that is that 70% of Americans believe that we should not overturn Roe v. Wade or a woman's right to her own reproductive choice. This is so critical that 70% of Americans are in agreement. This was part of a Pew Research report. 25% don't agree, and about 5% not sure what they think. But anybody who thinks this isn't about settled law or about mainstream views in America is wrong, because it's about almost 50 years of settled law, and it is about what mainstream Americans believe are their constitutional rights. And that is why it is so important for us to listen to those Americans and their long-held beliefs, starting with the laws that we got from England and baked into our Constitution, the right to privacy. Yes, people are right. The word privacy isn't mentioned, but it is in various amendments believed to be rights within the Constitution. But we have a Supreme Court made up of men and Ivy League institutions who now discuss in a decision that we don't really know exactly where it came from, this notion that privacy and a woman's right to her own reproductive choice somehow doesn't deserve stare decisis, that is, predicated on previous law, and somehow isn't in the Constitution. Well, I got news for a lot of people. If you have a Supreme Court who's going to take a run from privacy in the Constitution, as this decision does, it barely mentions the case law predicated that made decisions about a woman's right to privacy based on those issues. Is barely mentioned. Now, I'm sure it's because those justices decided if they had to agree that privacy was really there as a right, which we as Americans believe it is, against the government unwarranted search and seizure on you, the government spying on you, the government taking action against you that has not been followed in law. You know, I spent 2 years on the Judiciary Committee, and I really couldn't believe this. Somebody told me, actually a conservative judge passed this information on. If you ask them whether they believe in Roe v. Wade or settled law, they'll tell you, oh yeah, it's been there. But if you ask them whether they believe in the rights to privacy enumerated in the Constitution, and do they believe in the penumbra of rights that basically give us this right, that Connecticut versus Griswold, that Casey versus Planned Parenthood was decided on, a true conservative that wasn't going to uphold the law would tell you they didn't believe in that. So that's the conundrum. We had a bunch of smartest guys in the room from Ivy League schools who came here and hoodwinked the Senate into saying things like, oh, we'll follow, or I think stare decisis is very important. And yet, the same people are about to put their name on a document that says, we don't really think there's any strong holding here. We don't think there's any strong case. Well, there is a case. There is a case for privacy. I remember my first days on the Judiciary Committee when John Ashcroft, then Attorney General, tried to come before the committee and make light of the fact that the government was spying on Americans. And when I said to him, Mr. Ashcroft, this is a serious issue of the FBI and others using software technology to spy into the lives of Americans, he said, you remind me of a joke. I couldn't believe it. I remind him of a joke? And he went on to tell this story about how a little boy sat on Santa Claus's lap and said, I know whether you've been bad or good. And he says, oh, you're not Santa Claus, you're John Ashcroft. Now, he thought this was hilarious. And I reminded him, not everybody in America was laughing. And now look at where we are, 20-some years later, fast-forwarding on the rights to privacy that we have in the United States and how every day we have to fight for those rights of privacy. I know the presiding officer knows this because he's joined me on these issues, particularly as it relates to children's online privacy issues and so many other issues that this body and this institution is going to have to decide on. But Americans know, 70% of them agree that this is a mainstream, settled issue, and now are shocked to find that somehow somebody is proposing something to overturn it. Mr. President, I'm not even sure people understand. I just had a conversation with somebody who said, oh, you mean they're going to give some rights to men in determining the pregnancy and some rights for women? I said, no, they're talking about making abortion illegal. They're talking about passing a law that takes the reproductive rights.
Okay, apparently there's a problem with the downlink, so they're going to put me on a channel. So let's get ready for a delay, the mother of all delays. Okay, they're still waiting for the signal. Gardienne de prison, Vicky White, un agent correctionnel de l'Alabama, en fuite depuis le 29 avril avec Casey White.